Okay. So welcome everybody. Can everybody hear me clearly? And do you see the presentation? Can somebody confirm, please? Hello. Can somebody please confirm that you hear me and that you can see my screen? I don't see the chat either. Can somebody unmute him or herself and confirm that you can hear me and see my screen?
Yes, we can.
Okay, thank you. It took a while. Okay, so this module will be on introduction to intellectual property. So what you will learn is the different types of intellectual property. What is? Can everybody mute themselves, please? Again. Thank you. So during this module, you'll learn what intellectual property is. So the different types of intellectual property. Intellectual property is very important for the current knowledge economy and for industrial growth, and also the competitiveness of companies. In this introduction, you will learn the different types of intellectual property, the freedom to operate. So do other people have intellectual property which is blocking us from doing research or doing commercialization of new findings? What is prior art? Prior art means everything which is out there being published, patents, but also on the web publications, and that's then related to copyright. How do you identify possible new intellectual property so that you can recognize it? How can you protect it? And what's the value? And that's an important one that will be later on in one of the modules on investment analysis. What's the value of new intellectual property? At the base of new intellectual property, you have creativity and innovation. Leading to economic value and competitive advantage. And through the proper use of intellectual property, you can have a much better chance of transforming your creativity and your new innovations into economical value. Can everybody mute themselves, please? Somebody is not muted. Thank you. Intellectual property law recognizes a creator's right for ideas, creations, innovations. But there's a big important difference and a difficulty, and that's it's intellectual property, so it's something from the mind, which is different than the property, land or a house or a car, which you can build a fence around, or you can lock your car, or you lock the house in order to protect your belongings. So this is something from the mind, so defending it, it's much more subtle. But where can we learn a bit? The importance of things from the mind is growing, and this has been explained also by this gentleman, Professor Harari. Perhaps you've read one of his books. So he wrote already 3 important books. Sapiens, it was on an overview of the history of mankind, and then looking towards the future, so a little bit of a visionary book on how mankind will do in the coming years. Professor Harari worked at the Oxford University and then moved to Israel. He's very popular, so he sold many books, and every book is around 15 euros. So if he has royalties, so royalties are a percentage of the sales that the creator gets from the sale. So if he gets a 10% royalty, he would have, by selling his books, earned about 18 million by the end of 2018. $18 million is much more than he will be probably earning as a professor. So he's also traveling around and lecturing around the world like rock stars. In 2020, he was at the University of Leuven in Belgium, where I also attended his presentation, and it was very interesting. So the future is all about, according to him, and also in his book Homo Deus, the future is all about data and controlling data. So he has this new equation, which is an interesting one, stating biological knowledge times computing power times data is ability to hack humans. So in the past, it was important to control land and machines, so material, and humans, of course, to prevent dictatorships. But in the future, it's important to control and protect data, which is also material. So, and perhaps the legislation on intellectual property can help on managing data. So this is working towards transhumanism. So we're going to look at the different types of intellectual property based on the story of this gentleman, Leo Hendrik Bakeland, who is an alumni of Ghent University. He was a good scientist, but he was also a good businessman, and he knew exactly how to turn science into money. So Leo Hendrik Bakeland was born in Sint Maartenslaten in Belgium in 1863. Sint Maartenslaten is a nice village near Ghent. And he finished his PhD in 1884 in chemistry at Ghent University. Then he started to raise significant funds, and he started a company with those funds in 1893. He had a very broad interest in chemistry and science, and trying to solve problems that occurred based on using his science. And in 1893, so already the same year where he started the company, he filed the first patent on the use of fluoride, fluoride-containing salts for the preservation of meat and fish. It's fluoride salts. It probably worked. This is his patent, but there's of course different. Is it something different? Whether it will whether it would be healthy or not to use fluoride salts for preservation of meat and fish. That's another thing. But anyway, he got his first patent. I don't think it will be. It's not used anymore. Some of his other work fields where he did research in was the improvement of and the production of quality of photographic paper. Now everything is digital, but before you had films that were in the cameras to take pictures. And there were some issues with the old photographic paper, and he improved the paper and gave it a brand name Velox. And now people could use also artificial light, so being indoors to develop the pictures. And then he had a logo developed for his company called Nepera Chemical, which was based on the Kali equipment type von Liebig. You see here a Kali type of the lab equipment, which was also used in his logo. Here you see this Velox photographic paper with a picture of his family and with the logo of his company, Nepera Chemical Company. Then he sold his company in end of 19th century, so 1899, to Kodak, Eastman Kodak, for about $750,000 US. In those days, this was a huge amount of money. But then instead of retiring and enjoying his life, he reinvested all the money in an estate he bought, the Yonkers, near New York. And he started there to do research again with a team of 40 chemists, and his area of study was the chemical reaction of phenols and formaldehyde, so aldol condensations. It has always been intrigued with this reaction. You see here Bakeland in his lab in Yonkers. And then he developed the beginning of 20th century, so in 1909, the first patent, so invention was the first patent, first plastic ever used. And the product was given the brand name Bakelite. And you see here the patent of Bakeland for production of Bakelite, so the plastic, the first plastic ever. And this is his trademark, Bakelite, the material of 1,000 uses. So this was a production patent, how to produce it. And then he started also filing patents on the use of this Bakelite plastic material. For instance, he had patents on the use of Bakelite to make records. In the past, these records were made by grinding pearls and pressing them into plates, but this is of course much more expensive than plastic. So here you see his patent application for the use of Bakelite to make records with his signature from Bakeland. And this is a record where he registered his own voice, and this record is still available at the Ghent University Museum of Science. So if you'll be visiting Ghent University for some courses, it's worthwhile of visiting the museum, because you will find this record here, but a lot of other material that Bakelite produced using his Bakelite plastic. He established in 1910 the General Bakelite or Bakelite Company, and he produced, besides this records, other use like also lab equipment, pipettes, burettes for his friends in Ghent. And then also, for instance, if you saw some of these old radios, the cases, these old cases from these old radios were also made from Bakelite. Now, these radios are now worth quite a lot of money. My grandparents had one in the attic, but as a little kid, I was always interested in how these things look like from the inside, and I wrecked this old radio. And of course, it's gone. Otherwise, I would have had quite some money. Was this radio still with light bulbs? With this General Bakelite Company, he sold it again, his company, this time in 1939, after the merger with Union Carbide, to form the Union Carbide Plastics Company. And that time, Bakeland received $51.5 million US, which was even much more than the 750 40 years before. At his death in 1944, so at the end of World War II, the production of Bakelite and analogs thereof reached about annual production 175,000 tons. And it was used by over 35 large companies around the world, making an enormous amount of different products. So, based on the story of Bakeland, we came across different types of intellectual property. So this is what this module is about, to identify and to get you familiarized with the different types of intellectual property. So the first type of intellectual property is a patent. So a patent is a property right that grants the inventor or owner the right to exclude others from making, using, selling, or advertising the invention for a period of 20 years. So very important, a patent, which is also being published, is valid for a period of 20 years. Then we came across like Nepera. bakelite, which are trademarks. Trademark is a word, a phrase, symbol, design, or a combination, even now including colors and sounds, which identifies and distinguishes the source of the products or services of one party, of a company, of a person. And also domain names are currently by law linked to the trademark, because there were some issues in the past that people took domain names with a trademark and then sold it to people owning the trademark. Otherwise, they would put nasty stuff on this website. Then you have copyright. So copyright protects original works of authorship in a presented in a tangible, reproducible medium or expression. So an idea is not sufficient; it needs to be turned into a tangible matter. It protects the expression of an idea, but not the idea itself. And also software can be linked to copyright laws, and in Belgium you have even specific legislation to protect software. Also databases, and we'll come to that a bit later, are linked to copyright. Then trade secrets. Trade secret is anything, a formula, process, methods, know-how that gives the holder a competitive advantage and which is not generally known, which is not published. And also legislation or in court, they will look whether or not a company or a person has strict systems in place to protect the trade secret. For instance, a logbook where people names are taken up and a date when getting access to this trade secret. And this is important that you have systems in place for the judge to recognize that something is a trade secret. So if somebody would steal the idea or take the idea and go and sell it to a competitor company, this person will be prosecuted and has to pay for all the damages. And this trade secret lasts as long as it remains a secret. So if people don't mention it to other people, and the oldest trade secret is that you probably know is, for instance, the Coca-Cola recipe, this formula 7X. Then we have designs and models. So protected in the US as design patents. In Europe, it's a community design. And then in Europe, you have also recognition of traditional foods. For instance, champagne can only be called, sparkling wine can only be called champagne if it's originating from the region in France around Reims. Buffalo mozzarella is coming from a specific region in Italy. Parmesan cheese should come from Parma. But this is mainly from Europe. In the US, it's not following this quite strict. So in the US, you can buy sparkling wine with the name of champagne, coming not from France, but some the region, for instance, like California. Then breeders' rights. In the States, this is a plant patent. In Europe, this is a community plant variety. And this is by breeding that you generate a new variety, so not by genetic manipulation. If it's genetic manipulation, so there's a clear impact from an intellectual impact from man, then you can file patents in Europe. If it's just breeding and producing new variety, it's community plant variety in Europe and plant patent in the States. And then we talked about patents and the fact that it remains valid for 20 years. For specific industries like pharma and pesticide companies, for instance, or veterinarian companies, development time is very long. For a new pharmaceutical drug, for instance, it takes often 16 years before all clinical trials have been succeeded and passed. So for specific areas, specific companies, you can get an extension of the 20-year period with about 5.5 years. Now, some of the intellectual property rights come with a certificate, so you get actually proof, a certificate that you have filed and that you're granted new intellectual property. So for patents, you have a nice certificate stating that you have obtained and granted a patent. Trademarks, this duration is 10 years or life, because every 10 years you have to renew if you have a registered trademark, and then you will see the suffix R. Utility models, so that's a duration of 10 years, and designs can be for a period of 5 years, which can be renewed for another 5 times, so total 25 years. Some intellectual property do not come with a certificate. For instance, copyright, when you write down a book and so forth, automatically it becomes copyright protected. In the past, you had to clearly state copyright protected, all rights reserved, for instance, but that's even nowadays not necessary anymore. So copyright lasts 70 years in Europe, 70 years after the longest living creator. But the issue is always with copyright to have an official date. So to prove officially that you had this created on this date in comparison to, for instance, somebody else who said, well, I made this as well earlier. So it's important to have an official registered date, and we'll come to that a bit later on to see and give some examples on how you can get an official date. Database is also protected for a term of 15 years, and it is rolling, but it's very important that there should be human intellectual input in the creation of the database. So if it's machines creating a database, just collecting data, it's not protected. But if there's a human intellectual input, then you have also protection as intellectual property for a period of 15 years. Then you have also trademarks. So if you have a name of a product that you have been selling for some time, but it's not registered, then it's an unregistered trademark. You're also protected by law, but much, much weaker. And then you see sometimes this suffix TM. And then we have designs, non-registered designs, and this is more for fashion and in Europe. So in Europe, it's stated that if you have a new design and you show it for the first time on the catwalk in Europe, you're protected for 2 years. Now, if it's fashion, I think protection for 2 years is probably more than enough. So copyright, database, trademarks, not registered ones, designs are all forms of intellectual property, but not coming with a certificate. Now, this is a very important slide that you all must remember. It's perhaps the most important of this module. When you have created new things, first, it's very important to protect it before you publish it, because publishing data before you protect it can result in that you lose your rights as intellectual property. So first protection, then publication. If you don't do this, you can lose a lot of money. So for instance, in the past, we had a good PhD student who discovered a novel tripeptide, natural tripeptide, which had the effect of lowering blood pressure, but only for people who had a high blood pressure. So normal people didn't suffer. So it was a very mild pharmaceutical candidate with very little side effects and with a new mode of action. So this is fantastic, and pharma companies were looking and waiting for such a new product with a new mode of action for many years. But this PhD student sent in an abstract to give a presentation so it's half year before sending an abstract to give a presentation at a symposium. But unfortunately, and then in the meantime started to think about a patent. But then the patent examiner came back mentioning that this PhD student had submitted an abstract describing a little bit his invention. So this abstract that was sent in was considered prior art, and there was no possible way anymore to file for a patent, except for in the States, because the US patent legislation states that you have 1 year grace period. But then, of course, yeah, there was not sufficient protection, so nobody of the pharma companies was interested in licensing and further developing this product, so it was gone. And so, yeah, a lot of money was lost for Ghent University, and a very interesting molecule never got developed to treat people with high blood pressure. So, very important. First, protect your intellectual property, then look at publications. Here's another example of losing intellectual property, and it's about this, how it's called, gingerbread spread from Lotus, speculoos. So there was a TV series in Flanders called The Thinkers or The Inventors, where both gentlemen, De Meyer and De Smet, filed for a patent on their invention to make this spread, speculoos spread. This intellectual property, this patent, was bought by Lotus, the Lotus company, who started to commercialize it. Sales were booming, and then suddenly competitors start producing this spread. So Lotus started litigation, but then the court declared in 2011 that the patent was invalid. So they didn't do, the patent examiner didn't do a proper job, neither did Lotus to do a good due diligence on the patent and in IP. Because the court found out that the exact formulation already existed in 2002, which was also available online on the website in Holland called omawaspi.nl. So everybody now can make Lotus speculoos according to the publication of the patent, but the patent was rendered invalid since there was already prior art. Some years ago, I had a student, and we started looking into the use of various forms of intellectual property, and we compared the food industry versus the pharmaceutical industry. We had a double approach. First of all, we went asking important leaders in the food industry questions. This was a primary source. And then we verified what they mentioned through secondary sources, for instance, patent databases, trademark databases, and so on and so forth. And what we found out was that in the food industry, they used 24% of the companies were using patents. Domain names was a very important form of intellectual property, also trade names, also logos and trade secrets, even more so than, for instance, patents. And then recognition as regional product or recognition as a European community design or community food recognition. An IDEPO is a registration to get a first date, but I'll come to that a bit later. So this is what the people, the leading people, the managers in food companies mentioned as the different types of intellectual property that were important for them. The reason was why the food companies not always file patents, because they said there was no need. The protection was too narrow, too expensive. Indeed, patents are expensive. If you take a patent in the most important business areas like Europe, US, Asia, then you have to think about a cost of around 250,000 euros, which is, of course, quite a lot of money. But then we looked verifying primary data versus secondary, and actually food companies were using much less patents than what they thought. Roughly half. For domain names and trade names, they were quite on, but much less patents. Who are actually filing for patents in the food industry? That's mainly the very large ones, like, for instance, a Unilever or a Nestle. So the food industry is doing much less on intellectual property, especially patents, that, for instance, comparison to the pharmaceutical industry. So here you see the difference. For instance, in 2004, filed was 8,000 by pharma industry and only 2,600 by food. But the amount of patents being filed is going down because it's getting more and more difficult to actually have patents granted. So very important, before you move ahead with research and developing new innovations, you have to look what already exists out there. So this is prior art. Important to investigate if intellectual property already exists on a specific subject. And if it's the case, then you should ask the question, whether do you have freedom to operate? Can you still do something new in this area? And where do you have to focus on, which is still available, which is still free and not protected by others. And as scientists, you became, over the years, during your bachelor degrees, very familiar with doing searches in literature and in the public domain, like Web of Science, trade journals, MedTrack, and so on and so forth. But you're not that familiar with doing searches in patents. And you see here, some patent databases you have to pay for, but some others, like Espasnet from Europe, it's free. Also, Google Patents is free, where you can find a lot of patents. A lot of the new innovations are not written up in scientific literature, but they are written up in patents. Another example, sad example, is a few years back, I was in the jury of a PhD defense of a colleague in chemistry, and this PhD student had a lot of issues and problems doing the synthesis and making specific molecules because there was no publication describing this chemistry. And then I looked into patent databases, and unfortunately I found that about 80% of the molecules presented by the PhD student were already protected by patents describing also the complete synthesis of these molecules, which is of course a very painful situation to be in. So keep in mind, not only looking for prior art and existing things on a specific subject in scientific literature, but also in patent databases. And I have to, on a very regular basis, mention this to my fellow colleague professors as well, because they're also familiar with looking into scientific literature, but very few actually look into patent databases. And this is real life. So if it's written up in a patent, you can't do anything. For research, yes, but then basically you're doing research for somebody else. Here are some other websites where you can go and look for information on patents. For trademarks, a very important one is TMView. This is an international database where you can look for trade names which have been registered, by whom, for which different class of products or services. And then you have also for copyright, that's everything which you can find out there. Now, if you're working on some something and you need to talk to third parties, as I mentioned, if you publish something, you lose the possibility of protecting your intellectual property. So if you start talking to a third party, you can do so, but then you have to use something called a confidential disclosure agreement, which is similar to a non-disclosure agreement or a secrecy agreement. It's actually a contract that protects confidential information or a trade secret information from disclosure to third parties. Now I have to mention trade secrets, it's even if you have a CDA in place, it's better not to tell to anybody. I have an experience with developing some formulations or licensing beer formulations to a brewery, for instance, in the States. But then it's very, very difficult to protect those. So you give them the idea that you learn them how to do it. And then they change a little bit of the formulation, and then the discussion starts. Well, it's different and not the same anymore, so it's not falling under this agreement. So for formulations, for recipes that you developed, for trade secrets, for instance, never ever, even not under a CDA, my advice is never share this information, even not under a CDA or an MTA. And an MTA I'll explain a bit later. So a CDA should include the following items: definition on of the information that's going to be shared, how this information should be marked, for instance, confidential should be printed or not. You can stipulate that in your agreement. The limited purposes, why you have signed this secrecy agreement, why you are exchanging confidential information. A recitation on the confidential relationship and expectations, what people should do and not do. The time period, on average, is 5 to 8 years. And then a provision defining the remedy. This is an important one, jurisdiction and the governing laws. If you're in, for instance, making an agreement or starting discussions with a group, another continent, it's best that you say that the courts in your country are valid and that legislation. Otherwise, you have to go and travel abroad to do litigation in court there. So it's always better to have your own governing laws and jurisdiction taken up in the contract. And then signature dates and signatures of legal representatives. It's very important. It's actually for all agreements the case. You have to make sure that the people who are signing are legal representatives of that party. Otherwise, the contract can be invalid. Now, if you're going to exchange also materials besides information, then it's better to sign a material transfer agreement, which is similar to a CDA, but it includes also a description of the material that you're going to exchange and for what the purpose is that you're going to exchange this material for. You can also charge a little bit amount of money for the material or the prototype, and it's not considered an invoice. Now, as I mentioned, publications can cause the fact that you can't protect your intellectual property. For instance, you can't get a patent filed anymore or granted. This is also for invoices. So if you already sell some of the product, the invoice also is considered prior art. And if you sell already something before it's patented, this invoice can be the result that your patent is not granted. For CDAs and MTAs, so damages may be available against disclosure, but the actual public disclosure cannot be undone. So if, for instance, it's published, this is also out there, and you have the risk that it's not patented anymore. You lose a lot of money and you can sue basically the other party for breaching the contract, but you can't get the patent anymore. As I mentioned, in the States for patents it's different. You have still a 1-year grace period. So even if something is out there in the domain, in the States, if you can prove that you are the first inventor, you can still get the patent granted. And then, of course, trade secret information that is publicly disclosed is no longer a trade secret. Very important for intellectual property is awareness building. So that's one of the cornerstones. As I mentioned, I often talk to my colleague professors, raising awareness that they, besides looking into scientific publications, they also have to look into patents. Also, employees need to be trained on recognizing and understanding intellectual property and the related value, so that they don't go and talk to everybody and basically give away information which is of value to the company. And of course, this module in the course that you're following is also a form of raising awareness. Accurate record keeping, so you have to clearly write down all your findings, all your ideas, all the science that you do, sign it. And this was even for the States very important until 2011, when Obama signed the American Invents Act, where they also moved. Can everybody mute themselves, please? Hello, some people are, thank you. In 2011, Obama signed the American Invents Act, where the US is moving towards the EU being first to file. Before it was the first to invent, so you had to prove by records that you were the first inventor. Now it's like in Europe, the first to file. So he or she or the company that first goes to the patent office for registering a new patent will win. In the States, it's also now first to file, but it's first inventor to file. So if you can show that you're not the inventor, you're not the first inventor, you can still have the possibility to get the patent granted. So very important, good record keeping, also for when later on disputes start. And now it's first to file, it can be on 1 day difference, like the Rega Institute in Flanders from University of Leuven filed 1 day after or few hours after Boehringer Ingelheim patent on a molecule for HIV, and so they were too late, and Boehringer Ingelheim had the patent on this specific molecule for the treatment of HIV, so the first anti-HIV molecule. So it can first comes, and it can be even a few hours difference. Also having a system in companies, and you have the same at Ghent University, is an invention disclosure form, making people and students and researchers aware that you have this. This is a document that includes sections to completely describe your invention, also answering what type of problem you try to solve, if there is prior art, how other people are doing this, and it helps you guiding your and clearing your thoughts and organizing your thoughts on a possible new intellectual property, a new patent. Trade secrets, as I mentioned, very important. If you have a trade secret, it should be very well protected, and you have to have systems in place so that you can show that it's really a trade secret and that you're doing everything possible to keep it confidential. We discussed also copyright and some other forms like trademarks. It's also important for that. Designs, databases, that often you have an issue with getting an official date. Also before when it was first to invent, this was important in the States for patents. So how can you get an official date or an official registration at a specific time of your new idea, of your new creation. You can do that via notarial deed, but this is very expensive. It's minimum 500 euros. In Flanders, you have registration offices where people can go and register a contract, like a renting contract. But you can also describe your idea there and have it registered. But this is about 30 euros. Then the bailiff, and it's also quite expensive. It's 250 euros. Registered letter. This was actually in the past a poor man's evidence. So you send yourself a registered letter with next to the stamp, you cut out a little piece. So when the post office stamps the stamp, there's also part of the ink of the stamp going on the letter inside. So you can prove that you didn't send an empty envelope to yourself on that date. You have also for software programs, escrow registrations, and then you can do official deposits. So some countries, regions have systems for doing an official deposit. In Benelux, it's called an iDepot, which you can do at the Benelux Office of Intellectual Property and Trademarks Registration, which is only costing you 5 euros. Now, perhaps important to say that ideas or a concept is not possible to protect because you have to have a tangible form given to that. But there is a way, nevertheless, to protect it, and this is just a suggestion and advice. What you can do, you have your idea described and registered at an official deposit, and then you make this subject to confidential disclosure agreement. And then basically the other party, you protect it from being used by the other party because you have a CDA in place. So when they go and use it anyway, they are breaching a contract. So this is a way that you can also protect a concept or an idea. Value of patents. Here you see some data from some time ago, 2014. So there's less issue with intellectual property because it was from a pay site, PharmaTrac. So you see here the number of deals made. In those days, it was mainly central nervous system, so Alzheimer, Parkinson, and where most deals were made. And also the deal value was the highest for central nervous system, followed by oncology. Now, of course, this changes, of course, the area of interest changes over time, because I'm sure that the last 2 years, the number of deals made and the deal value for anti-infectives and vaccines, especially for COVID, has been surpassing central nervous system or cancer. The current trend in the past, Big Pharma was making early stage development licenses or even later stage developed licenses. Now it's moving more towards buying the company or the biotech startup companies or investing in equity. So you see here mergers and acquisitions, partnerships, but pure license agreements have been much less. It's only a small part of the deals between, for instance, biotech and large pharma. Also, the deal value, so the licensing again here is only a small part in comparison to the value of equity partnerships, mergers, or mainly what we're talking then is acquisitions. So Big Pharma is waiting for the biotech companies to bring technology a bit further to the market and then buying the whole company and assets in comparison to just taking a license on the developed products. Here you see some of the top licensing deals in 2014. You see the licensor, so the company or the person that developed the intellectual property, and the licensee, that's the buyer, so the company that in-licenses the technology. You see Ablings from Ghent University with Merck, and the deal value was 2.3 billion. Genmab and Janssen Biotech 1.9 billion. So in the pharma industry, there are big deals done, and the biggest deal in history in the pharmaceutical industry was US Pfizer, the largest pharmaceutical company, bought the Botox producing Allergen and also for eye products for $160 billion. But also in food, you have big deals done, like AB InBev, #1 in the world. Now, actually, until Corona, AB InBev had an annual turnover of $54 billion versus Pfizer, the largest in the pharmaceutical industry, 52. So actually, the biggest brewer in the world, was bigger than the biggest pharmaceutical industry. Of the biggest pharmaceutical company, Pfizer. Now with Corona, this changed because Pfizer, I believe, had almost 50% more turnover than before. So they're doing very well due to the Corona situation. And then Coca-Cola, the lemonade producer, with their formula 7X, merchandise 7X. This is the original formula from John Pemberton. It's kept in a vault in Atlanta, but their turnover in 2014 was 46 billion, with an operating income of 9 billion. Let's look at the value of copyright. Perhaps you know this lady, J.K. Rowling. In the past, she was a poor lady. She couldn't even pay for heating her house. So every morning, very early, she left for sitting in a pub with 1 cup of coffee the whole day, and she started writing famous books on Harry Potter. So she started writing a book, and then she negotiated a royalty in the order of 10%. So the royalty is meaning that, for instance, every book sold, a percentage of what the people pay is going to the author. If a royalty of 10% on the net sales means if a book is sold at $17, you get $1.7 per book. So by making this deal and writing these books, her net worth in 2007 of J.K. Rowling was 1 billion. It's on one book, if you do the calculation here. 8.5 million books sold at 17 euros per book, giving you 114.5 million in net sales. So for the first edition, for one book, she gets 14.5 million. And then you have all the branding and the movies, and you can even buy Harry Potter wands in shops and brooms where you can imagine that you're flying, and so on and so forth. But these are sold for very high amounts of money. So being an author can bring quite some money. So you here see that, and it changes a bit. The top 5 authors around the world: James Patterson was the biggest one in 2015. J.K. Rowling moved to the top very quickly in 2017. 2018 was James Patterson again. J.K. Rowling again. Stephen King, Michelle Obama sold a book in 2019, made 36 million. And then, so now, the value of money became less, and you see that they're increasing significantly their income. And in Belgium, it's important to mention, perhaps also in other companies, countries, the first 54,000 euros income received from copyright is taxed at 0%. So it's interesting to be an author, but keep in mind these are only the successful examples. There are a tremendous amount of authors who don't sell much of books, and they're of course living in poverty. Same goes for music. So it's very important as a musician that you write your songs. You can have a fee for performing them, but who makes most money of a song is the person who writes the lyrics and the music. So you see here it's more fluctuating. The top musicians, Katy Perry, One Direction still in 2015, but they're gone afterwards. In 2017, you had P. Diddy and Beyonce. The Weeknd was there. Coldplay. Then 2018, U2 moved up. Then you saw Ed Sheeran coming around. 2019, Taylor Swift, still Ed Sheeran. And then for the 2020 and 21, it's Kanye West who's at the top. So you see, for music, it shifts much more than for the authors. So we talked already a bit about the royalties. There are much more examples related to copyright, trademarks. But let's look at a little bit intellectual property now as an important part of tax and tax shifts. So, you know, these gentlemen, they're a little bit older, that's the Rolling Stones. And then you see these gentlemen, they're a bit younger, that's U2. And then this old gentleman, this is Pebbleton, and this is Coca-Cola. Now, they all have something in common. And what do they have in common? They have in common that they moved their profit center to Holland, because from royalties you can earn much more being based in Holland than any place else, because it's interesting for tax reasons. Also, for instance, I'll give an example here with the IKEA. I'm sure that some of you have bought some furniture at IKEA or some other stuff. An IKEA group is being controlled by the Stichting Inca Foundation. And this foundation controls the Inca holding that holds the rights of the trade names. The trade name IKEA, but also this trade dress, so this design of the buildings, and then the names of all the different furnitures and the design of the furnitures. And all the shops of IKEA around the world, they have to pay a lot royalties to be able to use this name IKEA and to use the name of the trademarks and to sell this furniture. So 250 or even above that, IKEA stores will pay minimum 3% of their annual turnover for the IKEA concept. So local stores are making a profit, but this profit is mainly going as a royalty to the holding BV in Holland as a royalty to be able to use these local shops to be selling this furniture and using the name IKEA. In 2007, the turnover of IKEA grew up to 21.2 billion. 2007, this was the gentleman, he passed away. And the Dutch holding made all the profit due to, because they had the royalties coming in. And in Holland, royalties or income from royalties is taxed at 0%. And then you can move out the money to countries like Monaco or the Bermudas, where then it's taxed as 0%. But the fact that in Holland you don't have to pay taxes on income generated from royalties This system is called the Dutch sandwich. I'll explain that a bit later. And this is how this gentleman, the owner of IKEA, made a lot of money without paying basically any tax. And it's not only IKEA that's doing this, it's other companies as well. And let's have a look how they do this. It's, as I mentioned, intellectual property is also a very important element of optimizing tax. And an important tax system was the double Irish and a Dutch sandwich. So dodging tax is not legal. It's also giving bad publicity. For instance, when people found out that Starbucks was dodging tax, they saw their turnover decreasing dramatically. But it's allowed to, you have legal allowed systems to optimize tax. And they can be very complex. So basically, you can also have quite some creativity and innovation in tax systems. And one of the important ones used past decades, and for some companies are still using it, is double Irish, which architect was Fergal O'Rourke from PricewaterhouseCoopers, in combination with the Dutch sandwich. And the architect from this was the former minister Joop Wijn. And this is a legal allowed system, and these systems are called base erosion and profit shifting systems, or BEPS. This is how in 2017 Google transferred 19.9 billion euro via Google Netherlands holding, where there were basically no employees, through Google Ireland holdings to the Bermuda black hole, not paying any tax on profit. Or, for instance, I'm sure that some of you play Call of Duty or World of Warcraft. So it's owned by Activision Blizzard, and they organized zero taxes through the Netherlands on their 5.9 billion euro in sales they generated between 2009 and 2014. So we're all going back to Holland. And this is how they do it. So how do you do this? You set up a company in Bermuda, or you buy a company in Bermuda where taxes are 0%, and where it's very easy to take out money going to the owner. Then you buy or start a management company in Ireland, where you have a very nice Irish law stating if a company is owned by a foreign company, profits can be moved and taxed over there. So here in Bermuda, where there's zero tax. And then this company owns all the intellectual property. So for instance, the US mother company moves all the intellectual property into this company. Then you have another Irish company where you subcontract the operations and collecting all, giving out the licenses and collecting all of the license income. So this is an operating company, and so both work together. And in between these companies, you have a license going to a Dutch company where licenses are given to different companies, also to the mother companies and other companies, sister companies around the world. And we know from what I mentioned that income generated from royalties is taxed at 0%. So all these companies here where you give a license are paying royalties. It's moving into Holland. Here in Holland, it's taxed because it's royalties at 0%. They got this license from the Irish companies. It's moving back into Ireland. And then Irish legislation says, well, you're owned by a foreign company, so we don't pay taxes here. You can pay taxes in Bermuda, where it's 0%, and the money easily goes out. And so basically, a lot of turnover is generated, but no taxes have to be paid. So in 2015, the double Irish is closed for new entrants. So it's new entrants, so people who are using this system can still use it. And you have new web systems now being developed where you don't even need the Dutch sandwich anymore. And the Dutch sandwich will end in 2021 for companies perhaps misusing the system. So if you are using it, then it's fine, then you can still continue doing so. So that's why you see with this based on intellectual property is an important element in optimizing tax. You see where, for instance, here US multinationals book their profit. Ireland, Bermuda, Caribbean, Switzerland, the Netherlands. So these are the top where you have less corporate tax. And then with the Netherlands, zero tax for income coming from royalties. There are new systems now in place, such as a single mold, the green jersey. And in 2017, the OECD estimated that these tools were responsible for tax losses of about 100 to 240 billion. Now it's even increasing, like Amazon. We have now companies with in the trillion turnover, and they're also using base erosion and profitability shifting systems. And actually, the largest of these BEPS transactions took place in 2015. And people in it, they only found out in 2017, 2018. They didn't know it was actually Apple. But what they did saw was that GDP in Ireland was increasing with 34.4%. And this was just due to this BEPS transactions from Apple. So Apple made a lot of money without paying any taxes. So you see here how you then end up in the top 10 of the value of trademarks and brands. So you had Google in 2011, Microsoft, Walmart, Vodafone, and so on and so forth. 2016, after their BEPS shift, Apple moved up at the top. In 2017, Apple was still there, followed by Google. 2018, Apple. 2019, Apple. 2020, Apple and Google. So you get at the top by just not only doing business, but then using BEPS systems or shifting tax. Here is a case now for how you use different types of intellectual property to protect your new creation or your new innovation. For instance, this is an example of at the University of Ghent, where Frank de Vliegere and the PhD student Ilse van Bree developed a model to predict the oxygen permeability of different polymers used for packaging of food. There was software used and also underlying databases that the research team created. Software was initially running at MATLAB, but this is a different software platform, also with a registered name, and we have to buy licenses. And this was available on a CD-ROM. Now CD-ROMs can be easily copied and then distributed, so it was dangerous for working like this. There could be perhaps a patent be written, but patents on software are not easily granted, or basically are not granted, except if the software is part of the equipment and it's steering the equipment. So you can't run software on a computer, but if you have software on an equipment that has been patented to steer and to operate the equipment, then the software can be patented as part of the patent application of this machine. So we didn't file for a patent then, of course. But software is and the algorithms are protected as a form of copyright. As I mentioned, in Belgium, you have even specific legislation on software based on this copyright law, and also databases. Remember, it's 15 years rolling average if there is intellectual property, intellectual input from man in the creation of this database. And we registered this algorithms and this idea via the iDepot. So we're building different hurdles for the protection of this model that was developed by Frank de Vliegere and PhD student Ilse van Bree. Further hurdles were introduced. First of all, a trade name was created. Proxypack was the first one, but that was already taken. So it moved to Predoxypack and registered as a trademark for the following classes for use: chemicals, packaging, and software, and which costed 240 euros. So trade name registration is much cheaper in comparison to, for instance, patent applications. And since it's a registered trade name, you indeed get a certificate and proof of registration. Also, the domain names were registered. You see all the domain names here, so that people couldn't take other extensions and so on and so forth, giving some issues and a lot of paperwork to settle this if you don't want to pay them ransom money, basically. But for 1 year to get all these domain names is about 230 euros. And then we start creating, of course, artwork, because artwork is copyright protected and lasts for 70 years after the longest living author. And this is, for instance, one of the artworks that were created. So a brochure on what Predoxypack. Then an eShop was created with a standalone version of the software. So CD-ROMs were not distributed. You didn't have to use MATLAB anymore. So people had to log in and put and use the online version to get their numbers. And it was out licensed to Pack4Food for 7% royalties on the net sales for a period of 10 years. As I mentioned, you can register trade names yourself. It's not that difficult. You can go to the Patent and Trade Name Office online and register for, first of all, look for the availability of the name, make sure it's not too descriptive. And this is an example of a spin-off company of Ghent University from Professor Koen de Wetting, and also myself as a shareholder. And here you see Cacao Lab. This is too descriptive. It's saying what it is. It's a lab looking at cacao research. So trade name is not possible as it is too descriptive. But you could use this name in a logo, and then the logo and design is still possible to register. So how to do this? For Benelux, you go to the website of BOIP, so the Benelux Office of Intellectual Property. You look for the availability of the name and the specific NISE classes, so the areas of use. If a word is not possible, like Cacao Lab, look at a logo or a design. And then for a registration in Benelux for a period of 10 years, one class is around 240 euros. You have also companies who are guiding you to do this, but for instance, they are much more expensive. Like one company in Belgium gave us, if you want them to do this, it's costing you around 4,000 euros. So by learning it to do yourself, you can save a lot of money. Third parties, when you first register or you submit the registration, can file an objection during a period of 6 months. But in order to file for an objection, they have to pay 1,000, now it's a bit more, 1,500 euros. But if there's no objection filed, then it's taken up as a registered trade name after a period of 6 months. And then you're fined for 10 years, but you have to police it, of course, and make sure that nobody else is using your name. That's something you have to do. That's not what the registration office is doing for you. So defend it against oppositions. And then if you're registered in one region, you can easily expand to other regions in the world using the Madrid protocol and still claim priority, for instance, from your first filing in the Benelux. So if you register a trade name in South Korea, it will be a similar system. And then you can expand via the Madrid protocol to other regions in the world. But if you do this yourself, be very aware of scams and false profits. And also make sure, monitor if you work with a patent and a trademark law firm, that they're not charging huge amounts of money to do this. For instance, here you see for the part, this is a trade name registration of Vegitech, which is a trade name from Ghent University for a new building where we look at and we bring in material pilot unit for vegetables from Inca Sampers. But then, so this is for 240 euros. But then you have to make sure, because there are some groups watching your registration. And then you get sometimes these letters, and they are sent to the finance department stating, well, this is, and it looks very official, is European Trademark Publication Register for Vegitech, and you have to pay 1,400 euros to get this published and so on and so forth. So it goes to the finance department, they recognize the name, and then often they say, oh, sure, this is okay, we'll probably have to pay this. But if you again study this, you'll see that it's a small company in Poland who have their own website with this nice logo, and they publish this. In order to have taken up in their database, you have to pay this amount of money. But it's nothing to do with an official recognition, so you don't have to pay this money. It's a thin line with being actually a crook. But they have a register, they publish this, but it's worth nothing. But you have to pay 1,400 euros to have this name there. So beware of false profits and of scams. You can also even defend your own trademark, what I did, because as I mentioned in the previous presentation, I have also a distillery. And here we have registered the name Angelicus for spirits. This is a gin, also in the States. And then I had an opposition filed from the Campari group, a huge group. They had lawyers in Washington, they had lawyers in Italy, and they had lawyers in one of the subsidiaries companies in Ireland where they make this Frangelico. And they stated, well, you can't use Angelicus because we have also a spirit, but it's a creamy liquor with Frangelico, and you have Angelic, so you have some letters which are the same, so you can't do that. And then I looked, it's very well described on the website of the USPTO, so the US Patent Office, how to deal with this. So they had all the lawyers. I did myself because I thought it is a nice case for the course on intellectual property. So I did the defense myself against the lawyers, and basically we came to an agreement that they agreed that we can still use Angelicus for the spirits, and no issue. So we settled it, and we're not going to make Frangelico, and they're not going to make Angelicus. So opposition was turned away. So this was the last slide. I hope you found it interesting. I will stop sharing my screen, and then we'll look whether there are questions. Are there any questions? There are no questions. Then I'll stop the recording. Later on, I will upload the recording also on Eufora. and I'll try to solve the issue with the recording of the module on project management. Apparently sound fell off. So no further questions. If not, then I'll stop the recording.